Hello, hello.
Oh, hello. How
Hi.
Something, but
Hi.
is a nuclear scientist.
Luckily, I finished my Housing Authority Commission meeting early. That was great. Unprecedented.
What? Just for us. Just for us.
Just for you. A su orden, a su orden.
Very good. Well, thank you so very much for coming today.
Absolutely.
Thank you so very much. I am loading everybody. All right. Well, it's 5:32. Do you want to get started now? And
Yeah,
I'm gonna it's recording.
great. If that works for you, yeah, I'm all set. And we have sharing capabilities on right now too. So
Yes.
once we go, so just get started.
Yeah.
All right, fantastic.
Thank you for
so
coming.
much for having. Thank you so much for having me. I'm Joaquín Torres, and I'm your elected Assessor-Recorder. And I just want to welcome everyone and thank you for joining tonight's estate planning workshop. And I want to thank you, Irene and Hera, for being present with us as always and providing this valuable information about the set of legal documents that make it easier for you and your families to honor wishes and make sure that your needs are met if you're unable to speak for yourself through our estate plan. I spoke earlier today with the African American Chamber of Commerce and their Black Business Conference about how important this level of work is in the context in which we're working. The context, I think, is something that needs to be sustained, not only because of the pandemic, but after the pandemic. And during that time, I had the privilege of being the director of the Office of Economic and Workforce Development. And I got to work collaboratively to create programs to ensure that we were investing in the diversity of our small business communities, focusing on our employees, to ensure that that was centering our city's cultural and economic vitality. Small business owners and their employees are really the heartbeat of San Francisco. And that's why it's important for you to feel from us that this is tailoring these resources to you and your needs so that you can be successful. And family childcare businesses are essential, we know, for so many reasons. The workforce behind our workforce, right? Since the beginning of the pandemic, we worked extremely hard to ensure that small businesses of all kinds benefited from more than $63 million in grants and loans. 3,000 small businesses, more traditional, benefited, including family childcare owners, tens of millions of dollars in fee and tax deferrals, and assistance in advocating and applying for state and federal funding. So in my role as Assessor-Recorder, I just want to say I am expressing my deep appreciation and support for all that you do to keep us successful and taking care of our communities, because you are the anchor for so many of us. I'm excited very much to share the details about this estate planning program in partnership with Hera. It would not be possible without them, but it truly is a partnership. And as I mentioned at the top, estate planning, as you all know, is a very important tool on both a personal level and a community level. We view it as being an important pillar and tenet to building intergenerational wealth, securing assets so it can be created. On the community level, estate planning is quite often an underutilized tool to address disparities in home ownership. Disparities in home ownership and inheritance, especially in communities of color. So oftentimes when estate plans are not in place, assets have to be sold to pay for the settlement of the estate, leading to the dissolution of all of that family wealth that people have worked so hard to create. and the community continuity that benefits when these assets are secure and they're allowed to be built and maintained over time, generation to generation. So seeing that dissolution happen is something that we want to prevent. And specifically in African-American and Latino communities in San Francisco, that is the reason why we want to see these estate planning services brought to bear for Black, Brown, and API communities. So I want to give a quick roll about the assessor's office. It'll be a little dry, but I think it's useful since most people don't know exactly what we do. So we are responsible for the single largest and most secure and stable source of funding for the city and county of San Francisco, $3.7 billion in total property tax revenue, of which $2.3 billion goes to the city's general fund to support our most essential services. And then about $1.4 billion that supports other public services. So you can see here 5.7% for federal funding, 13% for state funding, business taxes 15%, other local taxes about 12.2%, but for property taxes 33.2% in terms of the revenue that's brought in that we can count on in San Francisco. Of course, the conversations today are really around how stable are those resources going to be, what will be the impact based on changes in the economy and changes in the market that may impact that number and what the city is planning to benefit from. Next slide, please. Community engagement is essential to the work that we do. You can see here from the map of the places that we have been around San Francisco, really trying to make sure that people understand we are an office that is accessible, that if people want to hear more from us around programs such as the estate planning program or general education programs, that we are available for you. So if you individuals, I don't care how small a group may be or how large a group may be, I want to make sure that people get the educational support that they need to be successful, to understand how a government office is here to serve you, and also to answer any questions that might be coming up about new laws that might be passing or issues that might be confusing for you, even when we have culturally competent partners who can provide translation services, et cetera, it still can get wonky. As you can see here, we've been present through our assessor in the neighborhood, being present physically so we can meet people where they're at, property tax education that I've already mentioned, and then of course, our Family Wealth series, which focuses on a digital manner of reaching people. In this pandemic environment, we've leveraged it so that we can talk about financial resiliency, estate planning programs like today, but also around issues surrounding fair appraisals that people are seeing are not being provided in the private appraisal market, to make sure that people know what to watch out for, how to protect themselves, and also ask questions through that process. So once again, the wealth that communities of color, this is primarily an issue for us, communities of color who are impacted by bad actors, I'm going to say it, in the private appraisal market, know that there are signs to watch out for and questions that should be asked to ensure that your valuable assets are protected. Next slide, please. So estate plans, why? Just one data point to consider, 70% of Black Americans do not have a will. Why is that important? When it comes to estate planning, from an estate planning perspective, because once again, we want to see those hard-earned assets that have been worked so hard for, to stay in a family's hands, to stay in a community's hands from its perspective. And quite oftentimes, if you're not prepared, you have to go through a probate process, which can be extremely costly. $1 million home might translate to a $40,000 amount in terms of probate costs. And if you had that plan in place, that would not be the case. But if you don't have that plan in place, that's $40,000 it's going to be due to you. I don't know about you, but I don't have that lying around. That is one of the manners in which those assets that have been hard fought for are lost, because they have to be sold, and therefore the intention of personal wealth, community stabilization, cannot be realized. Next slide, please. So you can see here, again, the collaboration with HERA. It really does take a village. It is not a cliche at all. It is absolutely essential to the work that we do. Every touch point matters when it comes to the services being provided, and nonprofits are a huge part of that. To lower financial barriers to secure your will, a living trust, a healthcare directive, and a power of attorney. So over the next year, because of a $300,000 grant generously provided by the Crankstart Foundation and the support of HERA, there's 100 free estate plans or low-cost estate plans in the amount of $400 for moderate income households in the southeast sector of San Francisco. It's a great value for participants. Why? Typically, these cost $3,000, $3,500 for the suite of services that you'll receive here. And just an anecdote, back in February, we were tabling in Visitation Valley, and we met a woman who came up to us and said, I wish this had been around last year, because she just paid $2,500 for one component of the services that are going to be provided to you for free, or $400 if, and hopefully when, you take advantage of this program. So I'm very happy about the partnership with HERA. Culturally competent work, multilingual staff that can provide these resources. We have about a little over 50 families participating, and we welcome your community members to participate too. States are not just homes, but your assets. So please do take advantage of this work with us. Next slide, please. So just in terms of the location, you heard me mention the southeast part of the city. That's primarily where we're focused. We're trying to align home ownership rates with communities of color, because that's where we want to focus this work based on that data point I shared earlier. Bayview to Ocean View, Ingleside Heights, Excelsior, etc. Right? We want to make sure that these are the areas where we're reaching people, in addition to the Western Addition. We're using, in terms of what the income threshold numbers are, the California State Department of Housing and Community Development income limits that are published on December 31st of last year to articulate where the range is for qualifying participants. So here's an example: a single person making less than $102,000 per year is going to receive the services for free. If that individual, again, single individual, making between 102 to 125 thereabouts, that means that those legal services will be provided for about $400. A lot of conversations, reductions in your student loans for folks. So just pay attention to these numbers. This is another way for us to make sure that we're focusing on people who really need these services and can benefit from the reduced cost or no cost that we are seeking to provide to you. Next slide, please. So as I mentioned, we really were focusing on areas where the combination of both homeownership rates were meeting with communities of color from a statistical perspective, and that's why we're focusing on the Southeast at first in this pilot program, with a little bit set aside for the Western Addition. So next slide, please. If you have questions, here's the information where you can reach out, but there's no wrong door. So if you don't have the information that will be provided in the chat, you can always reach out to us at the Assessor-Recorder's office, or you can reach out to HERA directly through the numbers that you see here and the emails that you see here as well. You can always tweet me, and we will tweet back and get you that information as well. But you can also come on by City Hall if you happen to have business there or in the area. Just come on by, ask those questions, and we'll make sure that you can get connected. But the easiest ways are to email inquiries@heracalifornia.org. Assessor@sfgov.org is the same for emails to reach out to us. It'll all come back to the same place so that we can get you, your friends, your family members connected. Even if you think you may not qualify, please do reach out and ask so that we can get you as a participant who has been interested in this program, because we are hoping that this is not the end once we reach that 100 household threshold. So thank you all very, very much for being with us today. And I think with that, we're happy to answer any questions that you have. And I very much look forward to hearing the presentation that HERA has as well. Thank you so much. And Delia, we're going to put the information in the chat section.
Thank you.
Right. Hi, everyone. My name is Irene, and I work for HERA, Housing and Economic Rights Advocates. Thank you, Assessor-Recorder Torres, for that. And with that, I'm really excited to bring you today's topic on estate planning. And let me just test my screen share real quick.
Thank you so much, Irene. All right, have fun, everyone.
Please let me know if you don't see it well. Let me disable this. Hold on 1 second. All right, you should be able to see my whole screen that says Estate Planning 101. So briefly about HERA, it's a statewide nonprofit legal aid agency, and the mission is to ensure people are protected from mainly losing their home, usually the biggest asset they own. And we also help with student loan problems and debt collection problems. And then estate planning is part of the components that are involved in saving the family home intergenerationally. So today, we'll talk about the basics of estate planning, the what, who, when, why, and where. So throughout the presentation, we will get a little more interactive, and feel free to put your thoughts and answers or questions into the chat whenever you get prompted. So we're gonna start with some true or false. So this one already tells you the answer, but so people might say, I do not own anything, I do not need estate planning. And that's actually not true. Even if people who, 18-year-old that might not own anything fresh out of high school, they still have themselves. And there are important decisions regarding personal and financial affairs during lifetime, no matter what stage of life you're in. And during lifetime, when we become unable to care for ourselves for one reason or another, and especially after we pass away. So everyone will benefit from estate planning. So next one, I have 3 children, Omar, Oscar, and Olivia. I can leave my house to Oscar only, and that's true. And because estate planning involves with estate planning, we'll talk about trust and will and other documents in a little bit. There are lots of room, lots of freedom for us to personalize our wishes. So we don't have to equally split things all the time. I have a written will. My child does not need to go to probate court when I die. And that's actually a common misunderstanding. Because the probate process that we're trying to avoid, that Assessor-Recorder Torres mentioned just a while ago, a short while ago, it applies to people who don't have any estate planning done. And it also applies to people who have a will, because essentially probate is a process where the judge in the probate court will determine if this person, this decedent who passed away, has a will, and if so, whether the will was valid or not, and to kind of appoint executors or to follow the will's instructions on how to distribute this person's assets. So even if this person has a will, if this person doesn't have a trust, then this person still has to worry about probate, which is costly and takes a long time. And then the next one is, my children get along so well, I don't have to worry about anything at all. Well, what do you think? That might be true for the moment, but in some cases, unfortunately, children get into arguments or conflicts after the parents pass away, and sometimes issues don't rear their ugly heads until a big change in life happens. And a loved one passing definitely is a big change in life. So we just never know whether we can ensure that our children are always in agreement regarding financial affairs and other determinations. So hopefully by now there's a sense of like an increased desire to learn more about estate planning. So what is that? It's a process, and it involves ourselves, and it involves a lot of decision making regarding our property. So it's essentially giving our treasures to our loved ones. And it also addresses our future needs during lifetime if we're not able to care for ourselves, either short-term or long-term. So maybe out of all the estate planning documents, the most common one that people have heard of from popular culture or other sources will be the will. So will is a part of the planning process, but you do need to consider other documents as well to make your plan complete. So there are several main documents involved. So there is trust, and there's also, so besides will, there's also power of attorney and healthcare directive. During lifetime, when we make these documents, they can be changed. If we feel good and we're still healthy and able to make our own decisions, fine. We can always change and update them as life circumstances change. But at the date of death, the trust and the will no longer be changeable. It becomes irrevocable. So we can't change it anymore, and we can't cancel it anymore. So the final version of the will be also the last one. And then for advanced healthcare directive and power of attorney, these documents take care of things during our lifetime. So after death, these documents lose their validity as well. So that's a basic timeline. So next, why do we need estate planning? So we already touched on this briefly. It's mainly two components. One is for planning for our own incapacity during lifetime. So we want to designate someone to help us manage our assets, communicating with the bank or help pay for bills, things of that nature, and also to help us carry out our healthcare related desires and decisions if we're not able to do so ourselves. And the second big component, of course, is post-death planning or inheritance planning. We want to make sure our treasure go to the people or the institution or both that we love and we want to support. And then also naming the people that we trust to actually carry these wishes out. So because I spoke about the two components, the during lifetime versus post-death planning, we will also talk about these two separately. So when we are gone, so this is talking about post-death planning, what happens after that? So by law, if we don't have any estate planning done, or if we simply have a will, the rules regarding probate will govern whatever we have at the time of death. So probate code it has set this amount of $184,500. So that means if by the time we pass, if everything that we own, houses, cars, and well, cars are kind of exceptions, but houses, bank accounts, and our valuable oil painting, jewelry, the heirloom, everything added together, gross value over $184,500, then our estate. Estate is the asset that we own by the time we're gone. The estate will be subject to probate. So court will be interested in going through that costly and time-consuming process, which we want to avoid. And then how do we evaluate or appraise the value of everything we have? It's depending on the value of the date of death. So very specifically, the rule specify the amount and how the value is determined, and in what circumstances probate will be an issue. So there are also assets that are not subject to probate. So the first one here in this bubble is properties that are held in the decedent's revocable trust. So that's why we, in many cases, encourage clients to create a trust, especially if their estate will be over the amount that I just mentioned. And as you can see, any homeowner will most likely have amount over that 184,000 given Bay Area housing price. So properties that will be held in the trust, if we put the house into the trust, that house is saved from probate. And then the second one here, real property held in transfer on death deed. You might have heard of it. It's kind of like a alternative to a whole trust. There is this thing called transfer on death deed in the state of California, where it looks similar to a regular grant deed, but it's a deed that specifies who the beneficiaries are after the homeowner, the title holder, pass away. So it's similar to a transfer on death account beneficiary designation in that sense. And there's some limitations to that. We'll discuss that in a little bit. And the third one here is POD account. So that's pay on death account. You might have heard of this when you bank with Wells Fargo, Chase, Citi. You have the option to designate beneficiaries on the savings account or checking account that you have there. And the bank will just, after you pass, designate the balance to the beneficiary or beneficiaries in equal shares that way. So that if you designated beneficiaries on those accounts, that account and the balance inside will be spared from probate as well. So that's also good to know. And then the fourth bubble here is less than $184,500 altogether. So that's kind of a rare case these days, especially if you own a home, that everything you own together by the time you pass is less than that amount. But it is, in some cases, it is still the case. So that estate will be spared from probate. And then the lower three bubbles, property held by the decedent in joint tenant or joint tenancy situation. So you might see some husband and wife owning bank account as joint tenants. So it doesn't completely protect the couple from probate, but it does delay the process a bit. So that if the first spouse passes away, joint tenancy by law means whoever is the last man standing or last woman standing will get everything. So the survivor will be able to just have the whole balance until the second person also passes, or it could be more than two people if it's not a couple, until the last man standing or last woman standing passes. There is no probate occurring, but you can imagine eventually there is a concern for probate when the last person in standing passes away. So the middle bottom bubble here is property passing to surviving spouse or registered domestic partner. So this is similar to joint tenancy. This is more talking about a couple situation where it delays probate in that the surviving spouse can't have everything. And the last one is retirement account or death benefits property with beneficiary designated. So retirement accounts are kind of a special animal. We don't really put those into the trust. They always require a designation of beneficiary. And sometimes actually, well, it still takes a step for us to actually put beneficiaries there. And it's very important to do that. And we don't put that in the trust because there's some adverse tax consequences if we do so. So yeah, this is similar in that if you have designation of beneficiary there, the account manager, the financial company will just give everything that you have by the time of passing to your designated beneficiary or beneficiaries in equal shares. So that is different ways that we can try to avoid probate, or different assets that are not subject to probate. So today, the main topic will be property held in the revocable trust. So we will talk, there is also irrevocable trust, but that's not in the discussion today. Most of the people will benefit from having a revocable trust. In revocable trust, so this is a trust that, as I said, we can, as long as we're healthy and well, we can always amend it and even cancel it, have a new one. There's that freedom and flexibility. And you might encounter these terms like settlor, grantor, trustor, which means the creator of the trust. And then there's trustee and beneficiary. These things are the main parties to the trust. It works kind of similar to a contract where you need parties and different roles. And you see revocable intervivals trust or living trust. Intervivals meaning during lifetime. And then you see pour over will. So you see these terms. So during lifetime, when you create a trust, you are actually all three things. You're your own creator, the settlor, trustor, they mean the same thing. You're also your own trustee, which is the person that helps manage and carry things out. And also the beneficiary, because during lifetime, when we create a trust, we don't want to give up our control over our properties, right? So we're still the beneficiary in that sense. We're still enjoying our house, our bank accounts, and everything that we own the same way we enjoy them before. It's after we pass away, there's the successor trustee that will step into our shoes and help us manage the trust intentions. And it could be our children, it could be people we trust, and or a trust company or a trustee company that or a corporate trustee rather, who we hire to help us manage. And then the beneficiaries will also, after we pass away, the beneficiaries are the people that we want the properties to go to. Yeah, sorry about that. I have a phone call coming in. So the beneficiaries will be the beneficiaries after we pass away. That could again be our loved ones that actually receive the inheritance. And then you see some provisions that identify family members and identify who the trustee and successor trustees are. And also the important provision will be how we distribute our properties after passing. And there's tangible personal property, TPP, things like our jewelry, oil painting, those things that we may want to give to a specific person or people. And then specific gifts of monetary value we want to give to people that we love. Or it could be just in general, half of my things will go to so-and-so. So that's the residue. It's after all the specific gifts. Everything else is residue. And then common provisions also include how much we compensate the trustee, because it is a job to manage what we have and make sure the beneficiaries get what they should get according to the trust terms that we set up. So we specify that. And then accounting requirements. So trustee that successor trustees that help you take care of things, they're supposed to kind of manage money coming in and going out, so that's accounting requirement. And then some other clause, spendthrift clause, no context clause. These are clauses that are they're there to protect you as the trust creator. And when you are actually going through the estate planning process, the attorney that you work with will explain in more detail about how these terms and provisions actually protect you from different angles. So advantages from trust, if we just compare it with will or with, will or not will, there is a probate if we don't have a trust, right? So the biggest advantage will be probate avoidance. With living trust, properties held by the trust are shielded from the court probate process. And then it's also a private record. And some people really value that because if you have your estate go through the probate process and under court supervision, that becomes a public record. And that's why we hear things about famous people after they pass, the details of their will, because it's a public record. And then if there is probate, there's also statutory compensation to representatives who carry out the wishes in the will, or representatives that the judge appoint to help manage inheritance. And we'll see in a different slide that the statutory compensation is actually quite high. And in living trust situation, there is no statutory compensation. It's just in California, it's usually reasonable compensation, which is, it's not as rigid and high as the statutory compensation. And in living trust situation, successor trustee can do all the tasks as specified in the trust without having court approval, versus if you only have a will, or if you have no will and having to go through probate, the executor, the person carrying out the wishes in the will, they have to do everything under court approval. And you can imagine that takes additional time and cost, and it generate more cost that way. And then the next one here, that's a little bolded here. So if you are in anticipation of using Medi-Cal at some point, there might be a concern with estate recovery. So after passing, the government might, claim, may claw back some of the benefit that you have used during lifetime. Well, if you have assets in the living trust, starting January 2017, that portion of your assets held in the trust are shielded away from so-called estate recovery. So that's also a major benefit if you anticipate receiving such government assistance. And then overall, we'll see in a different slide with some calculations, your beneficiaries in the living trust will end up with more of your wealth than beneficiaries under probate situation. So very briefly, what is a will? Will contains your wishes and desires. So in that sense, it's similar to a trust. Trust also talks about in what ways you want your assets to be distributed. And so who receives what from you, basically. But then will, as we kind of re-emphasized, does not shield you from probate by itself. So probate is still a concern if you only have a will. So probate is a court supervised process, and it's basically the court's way of protecting the decedent's wishes or the decedent's rights. So because that person can't speak for him or herself, so the court is trying to help this decedent to achieve justice as much as possible. So it's theoretically a very good concept and theory, but a good concept, but it just when you carry it out, it is costly. And the court will, in the process, appoint a personal representative. So it could be called executor. Executor is usually the term used when you do have a will. administer is usually the term used when you do not have a will, but they're similar in the role that they carry. And if there's no will, how do we really distribute, right? You might be curious. It's the law actually specifies the order. So in this next slide here, it talks about kind of that order. If you do not have a will, who gets what and who gets things first, and then who's the second in line, and it's your surviving spouse being the first in line, and after that it's your children and grandchildren, and you know, issue means this your offspring, so it could be children's children, and then if they're not around, then it goes to parents and then siblings, and so it goes kind of by the order of naturally how close people are to us. And you can tell this is very limited because family situations can be anything. So in many cases, it doesn't really represent a decedent's actual desires. It's limited in that way. And then in the end, if you don't have any of these people around to take your treasures, it can even go to creditors, and it can only also go to the state at the end. So again, it just really doesn't reflect a lot of the people's wishes. And yeah, that's another reason why we want to make sure we have estate planning done. And this table, it's kind of similar idea. It shows the relationship, degrees of relationship. So person, and then the person's child, and you know, usually it's the spouse first, and then children, and then if they're not around, then go to parents. And so yeah, so it's that kind of a form or a chart that is just one way of seeing things. It does not reflect many people's wishes. And this flow chart here, you don't have to read the specifics here. This is more kind of showcasing how the probate process could be costly and time consuming. This is a screenshot from the Alameda probate court. And you know, when somebody passed away without anything but a will, or without even a will, then the beneficiaries or the children that will inherit need to file a petition for probate, and then had to publish notice, and in 4 to 6 weeks have to, if the bond is required, file a bond, and there's like a hearing date on the calendar. And so you can tell this process it has a very tight timeline, and there's many notices and a lot of paperwork involved. And it's really hard to do so without a experienced probate attorney, which is costly by itself. And then you file accounting, and that's why we're trying to avoid this probate process. And this is just a visual illustration of the process. So we talked about statutory fees. Probate, according to probate code, has will encounter these statutory fees that's owed to the court designated personal representatives or the executor that the testator, who is the one that made the will, has nominated. So it goes by the gross value of your asset. So if, say, by the time we pass, there's a house we own, and it's around 1 million. It's around 1 million, and forget other bank accounts and other assets. Even if all we have is that 1 million house, by the time we pass away, for example, the statutory fees to give to the executor will be $23,000. So that's significant amount. And let's see, so this statutory fees does not apply if you have a trust. And when you compensate your trustees, like I said, you can specify reasonable compensation. It does not have to be this amount. It could be a lot less than that. So just an example, again, comparing trust and no trust, which means probate is at hand. If we start with the same $1 million fair market value estate, it could be a house, could be everything added up together, and say if there's 300,000 mortgage balance and we take care of that, the net value become 700,000, and say we have the same figure for probate side. So the left side is trust, right side is probate. And the same cost for admin, the sale and working with people on selling the house, for example, same cost. We end up with the same balance here, $680,000. In trust administration, theoretically, you don't even have to compensate the trustees at all, and you don't have to hire an attorney to carry out the distribution. You can, the trustee, the successor trustee, can carry things out according to the trust terms by himself. So the beneficiaries start with this figure here, $680,000 to begin with. And on the right side, there's the statutory fee to the personal representative that I mentioned, and there's also a statutory fee to the probate attorney that's involved. So that's two sums of this figure. And so already starting the number that we have at the beginning of distribution to beneficiaries is a lower number here on the probate side, comparing to the trust side. So that's why probate is more costly, and that's why it's a good idea to consider trust, especially if we have assets over the probate threshold. So another example, just kind of to illustrate what we have talked about so far. Imagine this person, Pamela, after she passes, she left behind the following assets: a house that's worth not very much, 300,000, and sorry about that. And then imagine her house being titled as Pamela, trustee of the Pamela Trust, dated Christmas of 2007. And then the second thing she has left behind is 2 IRA account with this amount in total, and naming Ben as the beneficiary, and also having a life insurance policy of about 70K, and naming the mom as the first beneficiary, and younger brother Leo as the second beneficiary. And the mom passed away just a bit before, 2 years before Pamela passed away, for example. And then the fourth category of assets, checking and savings account, bank balance totaling 2,000, and naming boyfriend Tommy as the beneficiary. So what do you think? Does any of these need probate proceeding? Can feel free to put your answer in the chat. I'll give about 10 seconds. So thank you, Dalia, for participating. It actually, everything is shielded from probate, because even the house is titled to the trust, actually. So it doesn't mention the trust name here, but when you have a trust and you put the house into the trust, you hold the title differently. Instead of as a person, you hold the house, hold the title of the house as the trustee of your own trust. So, well, actually, it does mention the name of the trust is simply Pamela Trust. So we can tell from how she held title here that she actually had a trust and she put her house into the trust. So that's taken care of, shielded from probate. And then the rest of the document or assets here She has named beneficiaries, very good steps taken. And for the life insurance, even though the first beneficiary predeceased her, she has a younger brother that survived her, that was able to take that piece of property. So no probate is needed here. So with the same kind of mindset, let's look at the second example. Dear Judge Judy, does Alex's estate need probate proceeding? Alex passed away on March 31st, 2018, leaving behind a house titled to Alex, an unmarried man, 2 IRA accounts of that amount with no beneficiary designated, life insurance of $70K, designated elderly father Sean as the first named beneficiary and no second named beneficiary. Sean again, predeceased Alex by 2 years, and checking and savings account of $2,000, and kind of just saying my girlfriend being the beneficiary, and then all these people claim to be his girlfriend. Any of Alex's estate need probate proceeding? Yeah, very good, Pat. So actually, all of his estate will have to go through the probate proceeding, because there's no the house is not titled over to the trust, and there's no beneficiary that's designated for the IRA, and the only beneficiary designated for the life insurance died before him, and the checking and savings account beneficiary is too vague. So I briefly mentioned that one of those bubbles that categorize properties that are not subject to probate, one of it is the real property held in transfer on death deed, which is a special option for California residents and or homeowners. So transfer on death deed is, like I said, has some limitations. So not everyone will be eligible. So it could not be, for example, a, let's see, real property improved with not less than 1 or more than 4. So it could not be like residential, like a apartment complex, and it could not be a agriculture piece of parcel too large. So so yeah, so there's some limitation there, and there's also limitations. It's not set, it's not mentioned here, but say if you want to have 30% of the house go to one child and 70% go to the other, which, you know, it's not equally distributed, you can't do so on the transfer on death deed. So that's also a limitation there. But you can totally do that in a trust. And there's also some formalities required for transfer on deed. Beneficiaries must be identified by name, and then similar to the regular grant deed, it must be signed in the presence of notary and recorded, and it has to be recorded within 60 days. So that's something special about transfer on death deed. And then there's another form that you use if you want to revoke it, if you change your mind later on, and that needs to also be witnessed and notarized. So there are formalities that you need to follow, that you need to pay attention to if you choose this route for your estate planning for your house. And it's sometimes a good option for critically ill homeowners who don't have the luxury of time to go through the full trust creating process, but it certainly has its limits. And this is kind of the example of what it might look like. And so it's similar to a regular deed, except under there, there's a part about beneficiaries. All right, so we wrapped up the properties or the documents that we will need as the part of estate planning that take care of our inheritance planning, our post-death planning. So regarding documents that take care of things during our lifetime, we will then talk about power of attorney and advanced healthcare directive, which are only valid during our lifetime, that governs who will be our agent that cares or carry out our wishes, or help us be our advocate, help us manage affairs when we are no longer healthy enough to do so. So I'll group them together as we discussed, since they have a lot of similarities between power of attorney and healthcare directive documents. These are both very important part of your estate planning. As you can tell, regardless of how much we own, we want to have some certainty about who can help us manage our affairs when we are not able to do so. And it allows us to plan for incapacity. We name people that we trust to help us make decisions, and also communicate with third parties. And in healthcare directive, there are lots of room to specify, for example, which type of pain medication we're allergic to that we don't want to ever be used on us. And also, end of life decisions, there's preferences that we can indicate. Sometimes that alleviates our family's burdens when the time comes, when it's, kind of stressful and urgent. And it also, very importantly, avoid the expenses and potential conflict of a conservative proceeding. So we'll discuss that in a different slide. There's another court proceeding that we want to avoid if we're able to do so. So in both of these documents, let's see, we'll talk about power of attorney first. So power of attorney, it specifies the agent, who that person can be, that can help us, communicate with the bank or help us file tax return, and paying utility bills and things of that nature. You can specify how much authority you give to your agent, or how limited authorities you want to grant them. So it's very personable. And so you will be the principal, and your agent will be called attorney in fact. So that's some terminology there. And for both power of attorney and healthcare directive, it's good if we have several people in mind that we trust, and we can name who would be the first choice, primary person. And that person that you trust the most might not be in close proximity to you. Then it's good to have a secondary or even a third or more backup people. So maybe they're not the closest to you relationally, but they are really close to you physically. So with more people named in your documents, there are, it's similar to an emergency contact. You get more protected that way when the time comes. And it's good to always choose someone who's assertive, who can really speak on your behalf, and someone who's financially responsible, and someone that we want to we want to name as our advocate when life gets stressful. And then you don't have to just make those decisions once and done, and you can always change that when life changes. And it's also a ongoing discussion with our loved ones regarding what we would like. So conservatorship is the court proceeding that determines who can essentially act on your behalf if you're not able to carry things out yourself. And last year, there's a lot of news about, Britney Spears. You might hear other celebrities in the news. And so, yeah, if we're not able to care for ourselves, and we haven't set up documents like the power of attorney and the advanced healthcare directive, who can be the person that act on our behalf? That's a tough question that the court will try to address. And again, it might not be something that deep down we want. The person that's the child might not be the person you trust the most sometimes. It's just life is uncertain that way. So with that limitation there's also court supervision costs that's involved. So again, court proceedings can be cumbersome and costly. And if we can actually have a way to express who we trust the most, that's the best. That's always the best. And that also saves costs. So this is basically what conservatorship is, and why it's a good idea to try not to go that route. So in the healthcare directive arena, healthcare directive document, it doesn't take care of everything health related. When we work with a hospital, sometimes we will encounter other documents that are more suitable for specific situations. You might have seen a pink slip post form for people who are older and have some severe physical limitations, and it's a easy way for first responders to know this person's wishes, and that's a very specific form. And you might have heard of the DNR form, do not resuscitate, and that's also for a specific purpose. And there's also other end of life discussion or forms that hospitals use. So in your healthcare directive, when you have these other arrangements made, you can always refer to them. But just keep in mind that there are different forms and channels to kind of help us manage our healthcare plans or wishes. So this is a quick example of the post form and the example of the DNR form that are just kind of taking care of their own arena. So far we've talked about the documents during our lifetime, and also documents that manage the post-death arrangements. And when you want to start your estate planning process, you want to meet with your estate planning attorney if you are married, together with your spouse. And if you're not married, you meet with the attorney one-on-one. At HERA, as Assessor-Recorder Torres mentioned, we offer this service, and you can also find alternative resources where they provide estate planning services. And in the process, you will provide your personal and financial information, so the attorney can have a good idea of your net worth. And you will, in the process, also express your wishes, nomination of the people that you trust and the people that you love, and how you want to distribute your wealth. And you continue to discuss with the attorney, and the attorney will prepare legal documents, and you review the draft until you're satisfied, making sure there are no errors, and that you understand the important provisions that actually truly carry out your wishes. And finally, when the documents are done, you will execute it in the presence of a notary public for the most part. And for will, it's a little special. You sign it in front of 2 witnesses. Then at that point, your documents are legally effective, but that's not the end of the process. There's a lot of emphasis on this bullet point here. It says fund your trust. So the most important thing, if you're a homeowner, you will want to make sure you transfer title to make sure that your house is owned by the trust. So like earlier in the examples, Pamela owning the house as the trustee of Pamela Trust. So that step is also something that the attorney will help you guide you do. And until then, your house is outside of the trust and it's still not adequately protected from probate. So after that step is done, your estate planning is it is done at this point, and it's also a good idea to periodically revisit the documents and see if there's still all the wishes are still all your wishes are still being manifested through the terms, because life changes, and sometimes we get new family members, new grandchild, or some other changes. We want to reflect that in our documents. So it's a good idea to keep reviewing them with the attorney that you work with. So here's just a picture of some important or famous people in our recent history that tragically didn't update their estate planning documents in a way that really reflect their wishes. And not sure how much you're familiar, heard about, Barry White, who's separated with his second wife and lived with a long-term girlfriend, for a really, really long time. And then by the time he passes, the girlfriend tries to claim, but then because he never updated his documents, her name is not anywhere on the documents, and she wasn't able to claim it, even though deep down he might want her to take it. It's just impossible to tell. And it's just headachy when we don't have estate planning in place, or they don't reflect our wishes anymore. So it's important to consider this and to also make sure it's current. So that's the end of my presentation. Again, this is how you will find us: phone call, email, website, and this is our intake line, and you're able to schedule a time to speak with one of our estate planning attorneys on the team to get your process started. And if you're eligible for the Assessor's Office program, then you will benefit from the free or the lower cost. So it's worthwhile to check it out. And yeah, so I will stop share and see if there are some questions in the chat to address. I don't see any questions yet. If you have questions, you can feel free to type it up or raise hand. Okay, I see Sheila raising her hand.
When it comes to talking to them, you got to treat them like they're in the cartel.
Go ahead.
Right? You want to have a conversation? Take them to a
Hi, yes, my question is, does your office and or the assessor office's program cover trust tune-ups? In other words, my husband and I have a trust, but we haven't reviewed it in some time, and it may need some revisions. Or is it a package deal where you're looking to complete the whole process? Thank you.
Thank you for the question. Unless the assessor's office has a different answer, I believe trust amendments or so-called tune-ups will also be covered in the program, because sometimes revising the documents is just as important, if not more, than creating the documents from the ground up. And Renee has a question.
Yes, I was wondering, if you use one attorney to do your trust, is it necessary to stay with the same one if you moved or were out of, or if the attorney moved so far out of your area?
Good question. So the answer is no, you don't have to stay with the same attorney, and sometimes attorneys retire or they move away too, and
right.
So you have the freedom to choose a different practitioner to work with. It's just sometimes, some other times it's maybe easier if you stay with the same person who knows your history. Sometimes estate planning attorneys can eventually become your family friend. So it's up to your situation, but you certainly have the freedom to choose someone else. Good question.
Thank you.
Seems like we're good.
Any other questions?
Thank you. Valuable information. Thank you so much.
You're very welcome. Very excited that we got to discuss this. I'll give it back to you, Delia.
Well, thank you for coming. If there's not any more questions, Tina, can you put her the information again on in the chat? And are you doing any community in-services? Is there a way to set up a in-service in the, like coming into Lakeview to do on the site, on the spot consultations or anything like that?
Yes, definitely. We are open to organizing any in-person events that you might want to host. So feel free to contact me at any time, and Assessor Torres is more than happy to be on site as well.
All right, very good. I'll give you a call.
Great.
All right, any other questions before we go? All right. Thank you for coming.
Thank you.
All right,
Good night.
goodbye.